Hi, I'm Mark Cunningham with Grace Property Management here in Denver, Colorado. The last few months, we've been going through several important bills that the Colorado legislature passed in the 2025 session, explaining how they impact both tenants and real estate investors, landlords in Colorado. And this month, we want to talk about HB 25-1249, which is one of the more impactful bills impacting you as a real estate investor. It's titled Tenant Security Deposit Protections. Now, this is a 9-page bill, which, as you compare to many bills, is about average, but there is a lot of stuff packed into this bill. Some things just codify what has already been in place, and there are some significant changes to this bill as well. But a handful of things this does, and the bill does much more than what we're explaining here, but just some of the high-level overviews of some things you should be aware of. Number one, it lists the only reasons that you as a landlord may make deductions to the tenant security deposit. And it's not a blanket for any charges. It's very specific in listing out the things: rent, utilities, damages. So it's very specific. Not a significant change there to the way things were previously handled, but now that is delineated more. Secondly, it says that landlords must provide a written statement with exact reasons, that's the language it uses, for the retention of any portion of the tenant security deposit. This, again, not a significant change, but it's ensuring and enforcing the fact that if you make a deduction to your tenant security deposit, you can't just say we deducted $325.78. You need to give a listing and a detailed written statement with the exact reasons for those deductions. Not a significant change there. Number three, if the tenant then requests additional backup, they say, hey, I want more. Tell me about these charges. The landlord now must provide what they're saying is supporting documentation. They reference things like pictures, invoices, or inspection reports. So there's an additional layer now, this is new, an additional layer of what the landlord must be required to provide the tenant upon request if the tenant asks it. Now, one of the more significant parts of this bill is it redefines in Colorado what is considered normal wear and tear. So when a tenant moves out of a property, they may not be charged for things that are legally considered wear and tear. You live in a property, some things are just going to happen. Those may not be deducted for those costs. Now, what this bill does is it redefines the language of what normal wear and tear. So these are things legally that may not be back charged to this tenant security deposit. Let me read it and then point out a couple important features. It says normal wear and tear means deterioration, damage, or even uncleanliness that occurs based upon the use for which a rental unit is intended or reasonably and typically used without negligence, carelessness, accident, or abuse of the previous or of the premises or private property by the tenant or their guest. Let me just pause there for a minute. I'm going to go back. Here's the big change. What this specifically says is normal wear and tear may include damage or uncleanliness, as long as the damage or uncleanliness occurred within reasonable use. Now, if that leaves you kind of scratching your head, it makes sense. It could be a little bit confusing, and different people will interpret that different ways. But what it does is it broadens what may not be charged against a tenant's deposit to conceivably allow certain types of damage and certain types of uncleanliness. But then it goes on to say normal wear and tear does not include uncleanliness that renders a dwelling unit substantially less clean than the dwelling unit was when the lease began. So that word substantial is important there. Not a crystal clear definition of how to apply it, but there is the definition in place. Some other things that the bill does that are very important to be aware of is it carves out potential charges against paint damage and potential charges against carpet damage. And what it says is that you can only charge, as the landlord, you can only charge for paint or carpet for things that are substantially damaged. The reason they put this in place is because it's become common occurrence in Colorado for landlords to charge a lot of things for paint and or carpet wear and tear. That's just normal wear and tear. Walls get scuffed and carpet gets worn out and faded over time. And landlords in Colorado have been charging for those types of things, which they shouldn't have been doing. So this law goes further to say unless there is substantial damage to the carpet or the paint, you can't charge for it. In addition to that, it says that if the carpet is 10 years old or older, then under no circumstances may you charge for anything against the carpet, even if it's damaged. So that means if the tenant moved in and the carpet's 9 years old, and they're there for a year, and they move out, and the carpet is now 10 years old, and they trashed the carpet. They spilled ink and oil, and they tore it up. They literally tore up the carpet. You may not charge because that carpet has exceeded the life expectancy. It is now more than 10 years old. That is specifically written into this bill. It also requires, and this is massively important, requires the landlord to offer a pre-move-out walkthrough inspection with conditions. And there's a lot of conditions. We don't have time to go into those. But it has to be at a reasonable time, convenient to both parties. The tenant has to have to remove their furnishings or give them the opportunity to remove their furnishings. This is a pre-lease extension, a pre-lease expiration move-out opportunity with those conditions. It can also be done by video walkthrough. So there's a lot of conditions into this, but if the tenant requests it, the landlord has to grant it within those conditions. Read that section of the bill. The landlord has 30 days to return the tenant security deposit unless the lease specifically allows up to 60 days. If your lease says, I as a landlord have 60 days, then you have 60 days. But if the lease is silent, the landlord only has 30 days to do so. And in anything where the landlord violates these provisions, the penalties for the landlord, their liability, is for the wrongful retention, is triple the amount of the security deposit plus damages, plus attorney fees, plus costs. So the liability, the financial liability to a landlord to violate a clause within this bill is substantial and dramatic. You need to make sure you're getting this right. Now, all this bill goes into effect January 1 of 2026, and it's important to know that this applies to all landlords and housing providers in Colorado, regardless of the size. It doesn't matter if you own 1 unit or 1,000 units. It applies across the board to all housing providers in Colorado. The bill's complex. This is not legal advice. Seek out your attorney if you have specific questions about the bill. If you're a client of Grace Property Management, know that we do these things for you, ensuring that we keep you compliant as it relates to the fair application and return of tenant security deposits. If we can be a resource for you as a landlord in Colorado, reach out. Rentgrace.com is our website. Happy to be a resource if we can.